Why are LLCs used so much for asset protection? What's so special about them and why do we like them so much? I'm Michael Redden. If you have any questions or comments about this topic, please leave them down below. If you'd like to know a lot more about it, then you should read my book. You can get that at book.reddenlawoffice.com. If you just pay the shipping, then I'll send you out a copy. All right, so LLCs, that stands for Limited Liability Company, and it's a really special type of business entity. Most of the time, they just exist in the U.S. There are some other countries that have them, but for the most part, they're just U.S. things. They're kind of a hybrid between corporations and partnerships, and they're pretty much the favored instrument when it comes to asset protection and other things like that, because an LLC, it can be taxed in any way. It could be an S corp for tax purposes. It could be a C corporation for tax purposes. It could be a partnership. Sometimes when there's just one member, it's disregarded and the LLC just goes through under 1040. So we get that versatility to decide how we're going to be taxed. So that's why accountants and everyone's love it. And that's much easier to put into the plan and maintain because of that. But the real reason why we like the LLC is because it is something that can be member managed or manager managed. So the people inside it could manage it, or we could just designate another person who could be like that chief executive officer that could run the actual LLC. But unlike a corporation, we don't need the big formal board. And like a partnership, the partnership could name anyone who wasn't an actual partner to be running that thing, to be the general partner. Those people have to actually be an owner. We can name someone who is actually not owning the LLC to actually run it and be that manager. Additionally, LLCs are special. Okay? Sure, if the company goes out and hurts someone, the company's assets and things are at risk. But when you go have that car accident or you get sued personally, generally speaking in most states, you can't really come and take that ownership away like you can take the shares of a corporation. That's because, an LLC with those partnership qualities is like a partnership. We don't want someone to be involuntarily made to be your partner. You should have the right to choose your partner. If you have shares like a corporation, the shares, they're made to be traded. You don't expect to make that a long-term relationship business-wise. Partnerships are kind of like a marriage. Same thing for like the LLC members. You're not expecting that deep of a relationship with shareholders, and so shares can be seized, they can be taken from you. For LLCs and for a lot of times partnerships in most states, there's only going to be one remedy to go after those assets called a charging order. That's just a fancy order that says, hey, LLC, if you ever give any distributions out to this member, you've got to give them over to me to help pay their debts. Lots of LLCs will decide at that point, we're just not going to give member distributions. We're going to hold all that in there. And unlike corporations, if a corporation keeps a lot of money, doesn't send it out, you get extra taxes on it. LLCs don't. LLCs are still going to pay the taxes and everything like that, but they don't have to distribute actual money. And that's why a charging order is so powerful, because you can decide just to not take money out and put more pressure on the creditor to make a settlement with you to kind of settle that debt. The other thing about that is there are many states where that's the sole remedy. The only thing they can do to go after your LLC interest is use that charging order. And that's why we'll choose some places like Nevada, because that not only is that the sole remedy, it's been tested in their courts, and their courts are loath to allow anyone to use any other remedy, period. In Minnesota now, and in some other places, we might actually allow you to foreclose on the ownership interest. In Minnesota, that means that they can actually take your ownership interest away. Now, the statute says that they only can do that if there's not a reasonable time they could recover within a reasonable amount of time. That hasn't been tested a whole lot in our law. So is a reasonable time 20 years? I mean, if you garnished everything I took out of that LLC and you got all the money I was going to get, if it still took you 20 years, does that mean you can take the company? We don't really know yet. We haven't really settled that kind of thing. Additionally to that, when someone actually forecloses and takes it, they're what's going to be called like a transferee. They're not going to really get to come in there and run the company or push your partner around. They're just going to own that piece forever and get to have all those tax benefits and all that money benefit. But the other flip side to that is, if your partner, somebody decides, you know what, I don't like you, you took that away, I'm not going to distribute any money. And I've got the control. So we're not going to distribute any money out. Just because money didn't come out of it doesn't mean there wasn't income. So you could have gotten 300 grand in that LLC that's supposed to come out, not made it go out. And now that other person's got to pay taxes on that $300,000, even though they're not getting any kind of money. That's kind of an advanced concept. And that's another reason why we like LLCs, even when it's kind of taken like that. We could put some tax pressure and other things on the creditor to maybe settle or get those things back out. Because it's generally not in the creditor's best interest for an LLC to liquidate and shut doors, because they're probably not going to get all their money. Maybe not to get any money in that regard, because maybe the LLC has its own creditors. But primarily we want that charging order only protection, so that, hey, you can't take the money that's in there, just sit there and grow in the company. After we settle, then I can get that money. After we settle, I give you part of that money. But if you want any of that money, then you're going to have to wait me out. Wait us out. How long can I wait to get paid? Is it longer than you? Do I have other assets that are taking care of me in a trust or something like that? That's really what you're looking for in that charging order only protection. So that's why LLCs are our favored instrument when it comes to asset protection. It has that usual protection, just like a corporation would from the corporate structure if we keep those formalities. And if something does go bad and I go and hit someone or get sued personally, then you're looking at just whatever the LLC decides to dish out. I can decide not to get paid. We can decide that LLC don't pay anybody and put the pressure back up. So that's why LLCs are kind of used for asset protection. If you have any other kinds of questions about whether your transferee's interest or charging order interest, I know this is more of a meatier topic, more of a complex topic than we usually cover in that, but it's really important to understand why we're setting up those particular entities. It can be manager controlled, it can be charging order only, and even if they are in a state that they could take it from us, we can put the pressure up on them on taxes. Any questions about that? It's complicated, I know. Put a comment down in the comment section below, and I'll be happy to answer it.